Hello, my name is John Watts, and I want to address a question that somebody put on our website. And it basically was about a debt buyer lawsuit, asset acceptance. And this debt buyer had sued this person, and the case was dismissed with prejudice, which means the debt buyer can never sue again. Asset acceptance can never sue again. And the question was, well, okay, that happened, but we're getting calls, and actually the spouse was getting calls, the other spouse getting calls, the kid was getting calls on their cell phone, and asset acceptance was still demanding the money and still on the credit report. And so the question was, is this legal? And if it's not legal, how do we stop it? So first of all, when you have a dismissal with prejudice, this normally means that the case is over and that asset acceptance has lost and that you do not owe the debt. So if you do not owe the debt, there's no reason for asset acceptance to be calling your cell phone with a computer dialer. And often the question is, well, did we give permission to call? And if you have a court saying you do not owe the money, then there's really no basis for asset acceptance to call with a auto dialer or pre-recorded message. And so that brings to mind the TCPA, Telephone Consumer Protection Act, which can be $1,500 per call. And then on the credit reporting, if you don't owe the money, well, then there's no basis for asset acceptance to be reporting it on your credit report. And going back to the cell phone calls, if you can't call the person that you sued and lost, and they can't, or you certainly can't call the spouse who doesn't even remotely owe the debt, and we're talking about a debt that the judge says you don't owe, and you can't call the kid. So all those sets of calls to those three cell phones are going to be normally very illegal and probably pushing that $1,500 per call. And then the credit reporting violates the Fair Debt Collection Practices Act. And then we want to look at the original lawsuit to see, did that debt buyer, asset acceptance, did it have a basis to sue? Did it have any evidence? Did it ever intend to present evidence? Because it may be that that's malicious prosecution, which is a state law claim. So in answer to the questions, these calls should not be happening. This should not be on the credit report. Probably the collection lawsuit itself should never have happened. And the way to stop asset acceptance, and we just did this a couple weeks ago from the time I'm filming this, the way to stop it is you sue them in federal court. And you say, I want money damages to compensate me. I want statutory damages, and that is a set amount or a range of dollars that you get per call under the TCPA. And then look at state law, Alabama law, and you can receive punitive damages, for example, under malicious prosecution. So when you can sue the debt buyer, asset acceptance, that gets their attention. So they go, oh, well, maybe we shouldn't be illegally collecting against this person. Well, they need to realize that, but they also need to write out a check, and they need to get it off of your credit report. So hope this has been helpful. If you have questions, you can give us a call, 205-879-2447, or you can contact us through our website, alabamaconsumer.com. Thank you.